Chapter 26 Supreme Court. Unlike the American Constitution, the Indian Constitution has established an integrated judicial system with the Supreme Court at the top and the High Courts below it. Under a High Court and below the state level, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts, adopted from the Government of India Act of 1935, enforces both central laws as well as the state laws. In USA, on the other hand, the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. There is thus a double system of courts in USA, one for the center and the other for the states. To sum up, India, although a federal country like a USA, has a unified judiciary and one system of fundamental law and justice. The Supreme Court of India was inaugurated on January 28, 1950. It succeeded the Federal Court of India, established under the Government of India Act of 1935. However, the jurisdiction of the Supreme Court is greater than that of its predecessor. This is because the Supreme Court has replaced the British Privy Council as the highest court of appeal. Article 124 to 147 in Part 5th of the Constitution deal with the organization, independence, jurisdiction, powers, procedures, and so on of the Supreme Court. The Parliament is also authorized to regulate them. Composition and appointment. At present, the Supreme Court consists of 34 judges, 1 Chief Justice, and 33 other judges. In 2019, the Centre notified an increase in the number of Supreme Court judges from 31 to 34, including the Chief Justice of India. This followed the enactment of the Supreme Court Number of Judges Amendment Act 2019. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The Parliament has increased this number of other judges progressively to 10 in 1956, to 13 in 1960, to 17 in 1977, to 25 in 1986, to 30 in 2008, and to 33 in 2019. Appointment of judges. The judges of the Supreme Court are appointed by the President. The Chief Justice is appointed by the President after consultation with such judges of the Supreme Court and High Courts he deems necessary. The other judges are appointed by President after consultation with the Chief Justice and such other judges of the Supreme Court and the High Courts are as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. Controversy over consultation. The Supreme Court has given different interpretation of the word consultation in the above provision. In the first judge's case, 1982, the court held that consultation does not mean concurrence and it only implies exchange of views. But in the second judge's case, 1993, the court reversed its earlier ruling and changed the meaning of the word consultation to concurrence. Hence, it ruled that the advice tendered by the Chief Justice of India is binding on the President in the matters of appointment of the judges of the Supreme Court, but the Chief Justice would tender his advice on the matters after consulting 2 of his senior-most colleagues. Similarly, in the third judge's case, 1998, the court opined that the consultation process to be adopted by the Chief Justice of India requires consultation of plurality judges. The sole opinion of the Chief Justice of India does not constitute the consultation process. He should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to the government. The court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. The 99th Constitutional Amendment Act of 2014 and the National Judicial Appointment Commission Act of 2014 have replaced the collegium system of appointing judges to the Supreme Court and High Courts with a new body called the National Judicial Appointment Commission. However, in 2015, the Supreme Court has declared both the 99th Constitutional Amendment as well as the NJAC Act as unconstitutional and void. Consequently, the earlier collegium system became operative again. This verdict was delivered by the Supreme Court in the fourth Judge's Case 2015. The court opined that the new system, that is NJAC, would affect the independence of the judiciary. Appointment of Chief Justice. From 1950 to 1973, the practice has been to appoint the senior most judge of the Supreme Court as the Chief Justice of India. This established convention was violated in 1973 when A.N. Ray was appointed as the Chief Justice of India by superseding three senior judges. Again in 1977, M.U. Beg was appointed as the Chief Justice of India by superseding the then senior most judge. The discretion of the government was curtailed by the Supreme Court in the second Judge's Case of 1993, in which the Supreme Court ruled that the senior most judge of the Supreme Court should alone be appointed to the office of the Chief Justice of India. Qualifications, oath and salaries. Qualifications of judges. A person to be appointed as a judge of the Supreme Court should have the following qualifications. Number 1, he should be a citizen of India. Number 2, he should have been a judge of a high court or high courts in succession for 5 years, or he should have been an advocate of a high court or high courts in succession for 10 years, or he should be a distinguished jurist in the opinion of the President. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of the Supreme Court. Oath or affirmation. A person appointed as a judge of the Supreme Court before entering upon his office has to make and subscribe an oath or affirmation before the President or some person appointed by him for this purpose. In his oath, a judge of the Supreme Court swears, number 1, to bear true faith and allegiance to the Constitution of India. Number 2, to uphold the sovereignty and integrity of India. Number 3, to duly and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will. And number 4, to uphold the Constitution and the laws. Salaries and allowances. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined from time to time by the Parliament. They cannot be varied to their disadvantage after their appointment except during a financial emergency. In 2018, the salary of the Chief Justice was increased from 1 lakh to 2.80 lakh per month, and that of a judge from 19,000 to 2.50 lakh per month. They are also paid sumptuary allowance and provided with free accommodation and other facilities like medical, car, telephone, etc. The retired Chief Justice and judges are entitled to 50% of their last drawn salary as monthly pension. Tenure and removal. Tenure of judges. The Constitution has not fixed the tenure of a judge of the Supreme Court. However, it makes the following three provisions in this regard. Number 1, he holds office until he attains the age of 65 years. Any question regarding his age is to be determined by such authority and in such manner as provided by Parliament. Number 2, he can resign his office by writing to the President. Number 3, he can be removed from his office by the President on the recommendation of the Parliament. Removal of judges. A judge of the Supreme Court can be removed from his office by an order of the President. The President can issue the removal order only after an address by Parliament has been presented to him in the same session for such removal. The address must be supported by a special majority of each House of Parliament, that is, a majority of the total membership of that House and a majority of not less than 2/3 of the members of that House present and voting. The grounds of removal are two proved misbehavior and incapacity. The Judges Inquiry Act of 1968 regulates the procedure relating to the removal of a judge of the Supreme Court by the process of impeachment. Number 1. A removal motion signed by 100 members in the case of Lok Sabha or 50 members in the case of Rajya Sabha is to be given to the Speaker or Chairman. Number 2. The Speaker or Chairman may admit the motion or refuse to admit it. Number 3. If it is admitted, then the Speaker or Chairman is to constitute a 3-member committee to investigate into the charges. Number 4. The committee should consist of the Chief Justice or a judge of the Supreme Court, a Chief Justice of a High Court, and a distinguished jurist. Number 5. If the committee finds the judge to be guilty of misbehavior or suffering from an incapacity, the House can take up the consideration of the motion. Number 6. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the judge. Number 7. Finally, the President passes an order removing the judge. It is interesting to know that no judge of the Supreme Court has been impeached so far. The first case of impeachment is that of Justice V. Ramaswamy of the Supreme Court, 1991 to 93. Though the inquiry committee found him guilty of misbehavior, he could not be removed as the impeachment motion was defeated in the Lok Sabha. The Congress party abstained from voting. Acting ad hoc and retired judges. Acting Chief Justice. The President can appoint a judge of the Supreme Court as an acting Chief Justice of India when number 1. The office of Chief Justice of India is vacant. Number 2. The Chief Justice of India is temporarily absent. Number 3. The Chief Justice of India is unable to perform the duties of his office. Ad hoc judge. When there is a lack of quorum of the permanent judges to hold or continue any session of the Supreme Court, the Chief Justice of India can appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a temporary period. He can do so only after consultation with the Chief Justice of the High Court concerned and with the previous consent of the President. The judges so appointed should be qualified for appointment as a judge of the Supreme Court. It is the duty of the judge so appointed to attend the sittings of the Supreme Court in priority to other duties of his office. While so attending, he enjoys all the jurisdiction, powers, and privileges and discharges the duties of a judge of the Supreme Court. Retired judge. At any time, the Chief Justice of India can request a retired judge of the Supreme Court or a retired judge of a High Court who is duly qualified for appointment as a judge of the Supreme Court to act as a judge of the Supreme Court for a temporary period. He can do so only with the previous consent of the President and also of the person to be so appointed. Such a judge is entitled to such allowances as the President may determine. He will also enjoy all the jurisdiction, powers, and privileges of a judge of a Supreme Court, but he will not otherwise be deemed to be a judge of the Supreme Court. Seat and procedure. Seat of Supreme Court. The Constitution declares Delhi as the seat of the Supreme Court, but it also authorizes the Chief Justice of India to appoint other place or places as seat of the Supreme Court. He can take decision in this regard only with the approval of the President. This provision is only optional and not compulsory. This means that no court can give any direction either to the President or to the Chief Justice to appoint any other place as a seat of the Supreme Court. Procedure of the Court. The Supreme Court can, with the approval of the President, make rules for regulating generally the practice and procedure of the court. The constitutional cases or references made by the President under Article 143 are decided by a bench consisting of at least 5 judges. All other cases are decided by single judges and division benches. The judgments are delivered by the open court. All judgments are by majority vote, but if differing, then judges can give dissenting judgment or opinions. Independence of Supreme Court. The Supreme Court has been assigned a very significant role in the Indian democratic political system. It is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from encroachments, pressures, and interferences of the Executive, Council of Ministers, and the Legislature, Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court. Number 1. Mode of appointment. The judges of the Supreme Court are appointed by the President, which means the Cabinet, in consultation with the members of the judiciary itself, that is, judges of the Supreme Court and the High Courts. This provision curtails the absolute discretion of the executive as well as ensures that the judicial appointments are not based on any political or practical considerations. Number 2. Security of tenure. The judges of the Supreme Court are provided with the security of tenure. They can be removed from office by the President only in the manner and on the grounds mentioned in the Constitution. This means that they do not hold their office during the pleasure of the President, though they are appointed by him. This is obvious from the fact that no judge of the Supreme Court has been removed or impeached so far. Number 3. Fixed service conditions. The salaries, allowances, privileges, leave and pension of the judges of the Supreme Court are determined by from time to time by the Parliament. They cannot be changed to their disadvantage after their appointment except during a financial emergency. Thus, the conditions of service of the judges of the Supreme Court remain same during their term of office. Number 4. Expenses charged on consolidated fund. The salaries, allowances, and pensions of the judges and the staff, as well as the all administrative expenses of the Supreme Court, are charged on the Consolidated Fund of India. Thus, they are non-votable by the Parliament, though they can be discussed by it. Number 5. Conduct of judges cannot be discussed. The Constitution prohibits any discussion in Parliament or in a state legislature with respect to the conduct of the judges of the Supreme Court in the discharge of their duties, except when an impeachment motion is under consideration of the Parliament. Number 6. Ban on practice after retirement. The retired judges of the Supreme Court are prohibited from pleading or acting in any court or before any authority within the territory of India. This ensures that they do not favor anyone in the hope of future favor. Number 7. Power to punish for its contempt. The Supreme Court can punish any person for its contempt. Thus, its actions and decisions cannot be criticized and opposed by anybody. This power is vested in the Supreme Court to maintain its authority, dignity, and honor. Number 8. Freedom to appoint its staff. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference from the executive. He can also prescribe their conditions of service. Number 9. Its jurisdiction cannot be curtailed. The Parliament is not authorized to curtail the jurisdiction and powers of the Supreme Court. The Constitution has guaranteed the Supreme Court jurisdiction of various kinds. However, the Parliament can extend the same. Number 10. Separation from executive. The Constitution directs the state to take steps to separate the judiciary from the executive in the public services. This means that the executive authorities should not possess the judicial powers. Consequently, upon its implementation, the role of executive authorities in judicial administration came to an end. Jurisdiction and powers of Supreme Court. The Constitution has conferred a very extensive jurisdiction and vast powers on the Supreme Court. It is not only a federal court like the American Supreme Court, but also a final court of appeal like the British House of Lords, the upper house of the British Parliament. It is also the final interpreter and guardian of the Constitution and guarantor of the fundamental rights of the citizens. Further, it has advisory and supervisory powers. Therefore, Aladi Krishnaswamy Iyer, a member of the drafting committee of the Constitution, rightly remarked, the Supreme Court of India has more power than any other Supreme Court in any part of the world. The jurisdiction and powers of the Supreme Court can be classified into the following. Number 1. Original jurisdiction. Number 2. Writ jurisdiction. Number 3. Appellate jurisdiction. Number 4. Advisory jurisdiction. Number 5. A court of record. Number 6. Power of judicial review. Number 7. Constitutional interpretation. Number 8. Other powers. Number 1. Original jurisdiction. As a federal court, the Supreme Court decides the disputes between different units of the Indian Federation. More elaborately, any dispute between the center and one or more states, between the center and any state or states on one side and one or more other states on the other side, between two or more states. In the above federal disputes, the Supreme Court has exclusive original jurisdiction. Exclusive means no other court can decide such disputes, and original means the power to hear such disputes in the first instance, not by way of appeal. With regard to the exclusive original jurisdiction of the Supreme Court, 2 points should be noted. 1. The dispute must involve a question, whether of law or fact, on which the existence or extent of a legal right depends. Thus, the questions of political nature are excluded from it. 2. Any suit brought before the Supreme Court by a private citizen against the centre or a state cannot be entertained under this. Further, this jurisdiction of the Supreme Court does not extend to the following: A. A dispute arising out of any pre-constitution treaty, agreement, covenant, engagement, senet, or any other similar instrument. B. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. C. Interstate water dispute. D. Matters referred to the Finance Commission. E. Adjustment of certain expenses and pensions between the centre and the state. F. Ordinary dispute of commercial nature between the centre and the state. G. Recovery of damages by a state against the centre. In 1961, the first suit under the original jurisdiction of the Supreme Court was brought by West Bengal against the centre. The state government challenged the constitutional validity of the Coal-Bearing Areas Acquisition and Development Act 1957 passed by the Parliament. However, the Supreme Court dismissed the suit by upholding the validity of the Act. Number 2. Writ jurisdiction. The Constitution has constituted the Supreme Court as the guarantor and defender of the fundamental rights of the citizens. The Supreme Court is empowered to issue writs including habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of the fundamental rights of an aggrieved citizen. In this regard, the Supreme Court has original jurisdiction in the sense that an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. However, the writ jurisdiction of the Supreme Court is not exclusive. The High Court are also empowered to issue writs for the enforcement of the fundamental rights. It means when the fundamental right of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court directly. Therefore, the original jurisdiction of the Supreme Court with regard to federal disputes is different from its original jurisdiction with regard to dispute relating to fundamental rights. In the first cases, it is exclusive, and in the second case, it is concurrent with High Court jurisdiction. Moreover, the parties involved in the first case are units of the federation, centre and state, while the dispute in the second case is between a citizen and the government, central or state. There is also a difference between the writ jurisdiction of the Supreme Court and that of the High Court. The Supreme Court can issue writs only for the enforcement of the fundamental rights and not for other purposes. The High Court, on the other hand, can issue writs not only for the enforcement of the fundamental rights but also for other purposes. It means that the writ jurisdiction of the High Court is wider than that of Supreme Court, but the Parliament can confer on the Supreme Court the power to issue writs for other purposes also. Number 3. Appellate jurisdiction. As mentioned earlier, the Supreme Court has not only succeeded the Federal Court of India but also replaced the British Privy Council as the highest court of appeal. The Supreme Court is primarily a court of appeal and hears appeals against the judgments of the lower courts. It enjoys a wide appellate jurisdiction which can be classified under 4 heads. Number 1. Appeals in constitutional matters. Number 2. Appeals in civil matters. Number 3. Appeals in criminal matters. Number 4. Appeals by special leave. Number 1. Constitutional matters. In the constitutional cases, an appeal can be made to the Supreme Court against the judgment of a High Court if the High Court certifies that the case involves a substantial question of law that requires the interpretation of the Constitution. Based on the certificate, the party in the case can appeal to the Supreme Court on the ground that the question has been wrongly decided. Number 2. Civil matters. In civil cases, an appeal lies to the Supreme Court from any judgment of a High Court if the High Court certifies that the case involves a substantial question of law of general importance, that the question needs to be decided by the Supreme Court. Originally, only those civil cases that involved a sum of rupees 20,000 could be appealed before the Supreme Court, but this monetary limit was removed by the 30th Constitutional Amendment Act of 1972. Criminal matters. The Supreme Court hears appeals against the judgment in a criminal proceedings of a High Court if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to the death, certifies that the case is a fit one for appeal to the Supreme Court. In the first two cases, an appeal lies to the Supreme Court as a matter of right, that is, without any certificate of the High Court. But if the High Court has reversed the order of conviction and has ordered the acquittal of the accused, there is no right to appeal to the Supreme Court. In 1970, the Parliament had enlarged the criminal appellate jurisdiction of the Supreme Court. Accordingly, an appeal lies to the Supreme Court from the judgment of a High Court if the High Court has an appeal reversed an order of acquittal of an accused person and sentenced him to imprisonment for life or for 10 years, has taken before itself any case from any subordinate court and convicted the accused person and sentenced him to imprisonment for life or for 10 years. Further, the appellate jurisdiction of the Supreme Court extends to all civil and criminal cases in which the Federal Court of India had jurisdiction to hear appeals from the High Court but which are not covered under the civil and criminal appellate jurisdiction of the Supreme Court mentioned above. Appeal by special leave. The Supreme Court is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country except military tribunal and court martial. This provision contains the four aspects as under. Number 1. It is a discretionary power and hence cannot be claimed as a matter of right. Number 2. It can be granted in any judgment whether final or interlocutory. Number 3. It may be related to any matter constitutional, civil, criminal, income tax, labor, revenue, advocates, etc. Number 4. It can be granted against any court of tribunal and not necessarily against a high court, of course, except a military court. Thus, the scope of this provision is very wide and it vests with the Supreme Court with a plenary jurisdiction to hear appeals. On the exercise of this power, the Supreme Court itself held that, being an exceptional and overriding power, it has to be exercised sparingly and win caution and only in special extraordinary situations. Beyond that, it is not possible to fetter the exercise of this power by any set formula or rule. Number 4. Advisory jurisdiction. The Constitution under Article 143 authorizes the President to seek the opinion of the Supreme Court in the two categories of matters. Number 1. On any question of law or fact of public importance which has arisen or which is likely to arise. Number 2. On any dispute arising out of any pre-constitutional treaty, agreement, covenant, engagement, senate, or any other similar instruments. In the first case, the Supreme Court may tender or may refuse to tender its opinion to the President. But in the second case, the Supreme Court must tender its opinion to the President. In both the cases, the opinion expressed by the Supreme Court is only advisory and not a judicial pronouncement. Hence, it is not only binding on the President, he may follow or may not follow the opinion. However, it facilitates the government to have an authoritative legal opinion on a matter to be decided by it. So far, 2019, the President has made 15 references to the Supreme Court under its advisory jurisdiction, also known as consultative jurisdiction. These are mentioned below in the chronological order. Number 1. Delhi Laws Act in 1951. Number 2. Kerala Education Bill in 1958. Number 3. Berubari Union Case in 1960. Number 4. Sea Custom Act in 1963. Number 5. Kesav Singh's case relating to the privileges of the legislature in 1964. Number 6. Presidential election in 1974. Number 7. Special Courts Bill in 1978. Number 8. Jammu and Kashmir Resettlement Act in 1982. Number 9. Cauvery Water Dispute Tribunal in 1992. 10. Rama Janmabhoomi Case in 1993. 11. consultation process to be adopted by the Chief Justice of India in 1998. Number 12. Legislative competence of the centre and states on the subjects of natural gas and liquefied natural gas in 2001. Number 13. The constitutional validity of the Election Commission's decision on deferring the Gujarat Assembly elections in 2002. Number 14. Punjab Termination of Agreement Act in 2004. Number 15. 2G Spectrum Case Verdict and the mandatory auctioning of natural resources across all sectors in 2012. Number 5. A Court of Record. As a court of record, the Supreme Court has two powers. Number 1. The judgment proceedings and act of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. Number 2. It has power to punish for contempt of court either with simple imprisonment for a term up to 6 months or with fine up to Rs 2,000 or with both. In 1991, the Supreme Court has ruled that it has power to punish for contempt not only of itself but also of high courts, subordinate courts and tribunals functioning in the entire country. Contempt of court may be civil or criminal. Civil contempt means willful disobedience to any judgment, order, writ or other process of a court or willful breach of an undertaking given to a court. Criminal contempt means the publication of any matter or doing an act which scandalizes or lowers the authority of a court or prejudices and interferes with the due course of a judicial proceeding, interferes or obstructs the administration of justice is in any other matter. However, innocent publication and distribution of some matter, fair and accurate report of judicial proceedings, fair and reasonable criticisms of judicial act, and comment on the administrative side of the judiciary do not amount to contempt of court. Number 6. Power of judicial review. Judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactment and executive orders of both the central and state governments. On examination, if they are found to be violative of the Constitution, ultra vires, they can be declared as illegal, unconstitutional, and invalid, rule and void by the Supreme Court. Consequently, they cannot be enforced by the government. Number 7. Constitutional interpretation. The Supreme Court is the ultimate interpreter of the Constitution. It can give final version to the spirit and content of the provisions of the Constitution and the verbiage used in the Constitution. While interpreting the Constitution, the Supreme Court is guided by a number of doctrines. In other words, the Supreme Court applies various doctrines in interpreting the Constitution. The important doctrines are mentioned below. Number 1. Doctrine of severability. Number 2. Doctrine of waiver. Number 3. Doctrine of eclipse. Number 4. Doctrine of territorial nexus. Number 5. Doctrine of pith and substance. Number 6. Doctrine of colorable legislation. Number 7. Doctrine of implied powers. Number 8. Doctrine of incidental and ancillary powers. Number 9. Doctrine of precedent. Number 10. Doctrine of occupied fields. Number 11. Doctrine of prospective overruling. Number 12. Doctrine of harmonious construction. Number 13. Doctrine of liberal interpretation. Number 8. Other powers. Besides the above, the Supreme Court has numerous other powers. A. It decides the dispute regarding the election of the President and the Vice President. In this regard, it has the original, exclusive and final authority. B. It inquires into the conduct and behavior of the chairman and members of the Union Public Service Commission on a reference made by the President. If it finds them guilty of misbehavior, it can recommend to the President for their removal. The advice tendered by the Supreme Court in this regard is binding on the President. C. It has power to review its own judgment and order. Thus, it is not bound by its previous decision and can depart from it in the interest of justice or community welfare. In brief, the Supreme Court is a self-correcting agency. For example, in the Keshwanand Bharti case of 1973, the Supreme Court departed from its previous judgment in the Golaknath case of 1967. D. It is authorized to withdraw the cases pending before the High Courts and dispose them by itself. It can also transfer a case or appeal pending before one High Court to another High Court. E. Its law is binding on all courts in India. Its decree or order is enforceable throughout the country. All authorities, civil and judicial, in the country should act in aid of the Supreme Court. F. It has power of judicial superintendence and control over all the courts and tribunals functioning in the entire territory of the country. The Supreme Court's jurisdiction and powers with respect to matters in the Union list can be enlarged by the Parliament. Further, its jurisdiction and powers with respect to other matters can be enlarged by a special agreement of the centre and the state. Supreme Court advocates. Three categories of advocates are entitled to practice law before the Supreme Court. They are: number 1, senior advocates. These are advocates who are designated as senior advocates by the Supreme Court of India or by any high court. The court can designate any advocate with his consent as senior advocate if, in its opinion, by virtue of his ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. A senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instructions to draw pleadings or affidavits, advise on evidences, or do any drafting work of any analogous kind in any court or tribunal in India, or undertake conveyancing work of any kind whatsoever, but this prohibition shall not extend to setting any such matter as aforesaid in consultation with a junior. Number 2. Advocates on record. Only these advocates are entitled to file any matter or document before the Supreme Court. They can also file an appearance or act for a party in the Supreme Court. Number 3. Other advocates. These are advocates whose names are entered on the roll of any state bar council maintained under the Advocate Act 1961, and they can appear and argue any matter on behalf of a party in the Supreme Court, but they are not entitled to file any document or matter before the court. Comparing Indian and American Supreme Court. Number 1. Indian Supreme Court original jurisdiction is confined to federal cases, while American Supreme Court's original jurisdiction covers not only federal cases but also cases relating to naval forces, maritime activities, ambassadors, etc. Number 2. Indian Supreme Court's appellate jurisdiction covers constitutional, civil, and criminal cases, while American Supreme Court's appellate jurisdiction is confined to constitutional cases only. Number 3. Indian Supreme Court has a very wide discretion to grant special leave to appeal in any matter against the judgment of any court or tribunal except military, while American Supreme Court has no such plenary power. Number 4. Indian Supreme Court has advisory jurisdiction, while American Supreme Court has no advisory jurisdiction. Number 5. Indian Supreme Court scope of judicial review is limited, while in American Supreme Court scope of judicial review is very wide. Number 6. Indian Supreme Court defends right of the citizen according to the procedure established by law, while American Supreme Court defends rights of the citizen according to the due process of law. Number 7. Indian Supreme Court's jurisdiction and powers can be enlarged by Parliament, while American Supreme Court's jurisdiction and powers are limited to that conferred by the Constitution. Number 8. Indian Supreme Court has power of judicial superintendence and control over state high courts due to integrated judicial system, while American Supreme Court has no such power due to double or separated judicial system.